Now, good morning, friends. This is in continuation to what I had been saying earlier how and what we can counter these admission deeds. Now, the question comes that, on the contrary, when these executors, who are the record keepers under the CLA rules in 1937, wide section 43, it clearly states how an MU has to record the transfer with information also and without information. So, what does it read? No sanction shall be given where it appears that government claim to proprietary rights in the site is being denied, where the condition on which the land is held are forthcoming, and these conditions provide that the transferee shall sign an acknowledgment as to the condition on which the land is held. Such acknowledgment shall be obtained before sanction is given. Sanction shall not be given to a transfer which involves the subdivision of a suit without first referring the case to and obtaining the orders of the officer commanding in chief, the command. The management of land entrusted to the board under Rule 9 shall be subject to the following conditions. A. No sanction shall be given where it appears that the government's claim to proprietary rights in the site is being denied. Such cases should be referred with the recommendation of the officer commanding in chief to the central government for orders. B. Where the condition on which the land is held are forthcoming, and these conditions provide that the transferee sign an acknowledgement as to the conditions on which the land is held. Such acknowledgement as the condition on which the land is held shall be obtained before sanction is given. Subpara C. Sanction shall not be given to a transfer which involves the subdivision of a set with its first referring the case to obtaining the orders of the officer commanding in chief, the command. Then, if acknowledgement is to be taken, government is bound to show the grant deed. The acceptance of asking the acknowledgement is the production of grant. This is so clearly explained on page 560 of Cantonment Land Administration Rules 1937. When you read the admission deed para B, if the old grant is forthcoming and its conditions provide that the transferee shall sign an acknowledgement, such acknowledgement shall be obtained before sanction is given. But an acknowledgement should not be demanded if the old grant is not forthcoming, or if a definite proof of the terms of the grant on which the site is held does not exist. So, friends, it is so clearly written in CLA rules. But we people are harping on half based knowledge. Now, if you read various honorable court findings, it's very clear that revenue record is no proof to ownership and title does not transfer through admission deed. So, what has the honorable court in various judgments said? Read 2007 3 RCR Civil 748. However, the said finding based upon the entries in the revenue record alone suffer from patent illegality It is well settled that the revenue entries are not the document of title. The revenue entries are maintained for fiscal purpose only. Now, in Thakur Nirman Singh and others versus Thakur Lal Rudra Pratap Narayan Singh, AIR 1926 PC 100, it has been held to the following effect. Subsequently, in Shrimati Swarni versus Shrimati Inder Kaur, it was held to the following effect: mutation of a property in the revenue record does not create or extinguish title, nor has it any presumptive value on title. It only enables the person in whose favor mutation is ordered to pay the land revenue in question. The learned additional session judge was wholly in error in coming to the conclusion that the mutation in favor of Inder Kaur conveys title in her favor. So this judgment was finally given. Another court judgment 2019 AIR Supreme Court 719, mutation of land in revenue records does not confer or create or extinguish the title of such land, nor does it have any presumptive value on the title. It only enables a favor mutation is ordered to pay land revenue. 1996 6 SCC 223, 2009 5 SCC 591, a number of judgments. The Honorable Court in 2024 AIR Supreme Court Civil 348, property law, grant of occupancy rights. Revenue records are not documents of title. Commissioner's order distinctively denying right of occupancy to plaintiff vendor is evidence that renders these revenue entries unworthy of acceptance. Sale deed executed in favor of plaintiff also tilts the balance against him. Vendor cannot transfer a title to vendee better than himself in possession. Read Honorable Supreme Court case. This is regarding now cantonments where Union of India versus PT Ankleshya, Civil Appeal number 609-11 of 1980, where it was clearly read in the Supreme Court case. In Purushottam Das Tandon Appeal 5931 of 1983, or you could search 1986 Supplementary Supreme Court Cases 720. Further, that GLR Jamma Bandis 1203 of 1980, Punjab and Haryana High Court, Mahinder Singh versus the Commissioner Firozpur Division, change of revenue records without the consent of the owner are not admissible. 2799 of 2002, Punjab and Haryana High Court, Punjab Land Revenue Act 1887, Section 3536 was discussed. Entries in revenue records, change of revenue entries cannot be changed without prior notice to the person likely to be affected. 2014 1 CCC 836, revenue record does not confer title. GLR entries cannot be treated as evidence. Now, finally, I'll nail the coffer. AIR 1935, Lahore 558, 51567 of 1934, cantonment records, General Land Register of Cantonment. The judge is clearly reading, I am illicit faith should not be placed on them. Corroborative evidence from other record is necessary. This is what he's giving a finding. So, friends, we have a number of laws, but We need a chain. What I've been telling you in my earlier videos, that we people were always revenue free grants. We were never old grants which are subjective to a governor general order. Thank you. Good day.